on a very interesting and topical subject, new labor code implementation and industry preparedness. Friends, as you are aware, from 1st April uh, 2026, this code will implement because rule is also uh, in the process of coming, and the government has given deadline of 1st April. So as you are aware that on 21st November 2025, India decided and took this historical step because labor law always is a very sensitive issue related to masses or related to political turmoil. So after decade of fragmented 29 different labor laws have now converted into four unified labor code. The Code of Wage, Industrial Regulation, Relation Code, Social Security Code, and Occupational Safety, Health and Working Condition Code. Earlier, there was so many PF Act, ESI Act, various acts were there, and I was a student that time when we were having a employer-employee definition different in all different labor laws also. So it is always dispute related and always uh, bound to happen the confusion by implementer and everybody. Now, this is the largest reform, labor reform in 75 years of Indian independence, and it is reshaping how India uh, uh, works, hire, pays, protect, and regulate its workforce. This is very a important thing, and this is very different also because without labor you can't work, and the growth of any economy it depends upon the working condition and engage and the amount which they are getting should be protected them. So it's the first time in India we are seeing one wage definition for all compliances. I told you earlier the wage definition was different in all laws, all acts related to labor law. One consolidated security, social security architects, PF, ESI, and various other policies which are there. That is a one policy. One is structured industrial relation framework. And the most important thing is that one integrates the safety and working condition, which is the hallmark of growth of our country's economy, because if worker is strong, worker is healthy, then the work will also be healthy. So this shift is not merely legislative, it is philosophical. No doubt, the law has provided various things, but this changes which was desired, required, is a philosophical. It's single India's transition from compliance heavy, inspection driven era to digital transparent data led governance model. Now you can understand that this model, which is always bulky books, bulky forms, bulky things, and then always there is a fear of inspector. Now there are so many things which they have tried to cover up, and they try to loophole or plug the loopholes also. If it is aligned, which is expected, then the plan of India 1 trillion economy will be uh, completed, and these ambitions we can achieve. But every major reform which is taking place, it requires two things: opportunity and challenges, and many more unanswered questions. Because today, when you are talking that the new law has come, so what is it means? What are the new issues are coming? This, if the word is not clear, what is the meaning of this? And today, our objective is to decode all three clearly and practically: opportunity, challenge, and what is unanswered. So these changes mark a historical shift, which I had told you, not only in compliance, but in a philosophical way also in the labor governance. So one is first paper to digital, confusion to consolidation, from scatter to obligation to unified framework, and then for reactive compliance to proactive workforce governance. That is the uh, important part which is taking place. But let us be honest and let us understand this part. The reform of this scale cannot be just like that you have announced, and implementation is easy. It is definitely will bring discomfort because you have to this this law is challenging status quo. The status quo in favor of industry, in favor of labor, everybody. So if labor something which they were getting and now they are not getting, they will create challenge. And in the industry which is paying X, now they are paying X plus, then they will create a problem. So now the point is they simplified, but they are also you also restructure is taking place. They unified, but they also tighten responsibility. They bring clarity, but they also raise various new questions, and new questions are relating to new interpretation. So the government has indicated that the implementation of four labor code is expected to take effect from 1st April 2020. We have waited long, and we have organized 4 or 5 programs under this pretext that this year is coming, this year is coming. But now I think everybody is serious, and they are marking a major shift in Indian labor regulatory framework. In preparedness to this transition, draft rules relating to this labor code were placed on public comments and recommendation, enabling industry stakeholder, professional, and policymaker to provide feedback before it is implemented. Now, uh, the proposed implementation date approaches the business, HR professional, compliance officers, policymaker must understand the practical implication of new regulatory regime. The transition from the existing labor law to the new code will require organization to revisit employment structure, wage policies, social security obligation, industrial relation, mechanism, and workplace safety standard. All these things has to change, has to bring to the par the law is asking and expecting from the industry. Friends, this webinar aimed to provide comprehensive overview of new labor code and discuss how industry can prepare for upcoming changes. Expert from regulatory bodies, ex-regulator, legal fraternity will definitely will deliberate on the various compliance requirement, implementation challenges, and strategic approach to ensure that a smooth transition into the labor code framework, how it can take place. So today we will discuss overview and understand the new labor code, new challenge, new change, a key change affecting employer and HR practitioner, implement challenge and transitional issue, and industry preparedness and best practices. Now, for this, we have invited none other than Mr. Anupam Malik, who can speak hours and days on this subject because he has had people service, corporate profession, and he was former additional labor commissioner of Haryana and also a member of core committee of drafting of new labor code, new labor law. Post this superannuation, he is actively advising industry and strategic HR restructuring. He is known for successful handling complex industrial relation situation in industry. And friends, whenever I'm talking to Mr. Malik, I can tell you one very important point. The way he is thorough of the subject, and you ask question and he will the answer is ready. And that is his command. And then second is he knows the what is the genesis of this particular issue. You may be thinking labor law is a compliance, but he thinks he has eaten labor law, he has walked with labor law, he has done labor law, in the entire life he has done this work. So his expertise, knowledge is superb and par excellence. And I have seen no other speaker who is so thorough than Mr. Malik. And we will definitely get the same thing which I am saying today to understand about the concept of the entire thing. Friends, other than Mr. Malik sir, Mr. Nitesh Chatwal, Associate Partner Corporate Professional and Compliance Corporate Professional, will also be participating in this and he will deliberate. So without taking much time, I will request Anupam sir to take up this topic and tell the industry that how to implement this and how industry should prepare themselves. Definition of wages, definition of remuneration, definitions of various aspects you are taking told every day in the newspaper we are writing there's a budget of this company has increased because of the labor code. Budget of this company on the expenditure side has increased, and some of the companies got the market effect also because their profitability will reduce by implementing this. So if this is happening, so it means the labor class will get maximum. But some people who are not understanding this larger picture, they always create what is not receiving, but what is missing and what they are not getting now. So let's discuss with Malik sir and and Nitesh about this. And after that, we will have question answer. So I will request all of you that whatever your queries are there, you please give, and Malik sir and Nitesh will give answer on this. Friend, before closing this, I thank everyone to join, and I will request Anupam sir to take over and guide us, guide industry, guide professional that how to face this particular thing and how strategically we should manage. Over to you, Anupam sir.
Pawanji, thank you very much. This is a pleasure to be with you and your whole system of conducting webinars. Even in the earlier webinars, people keep asking me after seeing your YouTube recordings, they asked me, who is Mr. Pawan Kumar? How is he so thorough about everything? I go, no, he is master of everything. And put him in any situation, he is ready to talk about it. So a person who is corporate law master, he has to know everything. So must appreciate your hold of, this is a talent, natural talent, I would say, or whatever you have acquired, that you can put you in any situation and you are ready to handle it. You can
Thank you,
drive
sir.
any vehicle. You can fly an aircraft, you can fly, you can do anything. So here also labor code, you've given a very nice introduction of things that have been happening. Of course, we've been together for since 2007 when I've been lecturing on compliance management in the Institute of Company Secretaries. You are the one who initiated me into this association with the Institute of Company Secretaries. Thank you so much. And I love the association with you for so many years now. It's a privilege, and I'm obliged to be with you and your system. And I am pleased to present all this. I'll do my best. Okay, coming back down to the topic now. As Mr. Pavan has said that so many labor laws, numerous labor laws have been subsumed into 4 labor codes. It was long overdue, and it's a bold beginning the government has taken, big step the government has taken. You see, such big changes don't go, everybody likes change, but nobody wants to go through change. That's a normal negative inertia in a human mind. That you want to enjoy the fruits, but you don't want to grow or work hard for it. Anyway, now that the job is done, it is more important for us to learn how to live with it and survive and thrive. We need to understand, in the earlier webinars also, I have explained that these changes have not been brought out of sheer imagination. All these changes in the new labor codes have been brought out on the basis of case law from the Supreme Court and the High Court and the past experiences. And a lot of people have contributed to it. Of course, I was part of the team. There were very serious problems in practical implementation of various labor laws. But now the target is to make things simpler for implementation and simpler for and provide all the protection as assured in under the Constitution of India. Next, Shivam, next. At the outset, I'll put this webinar into two parts. Try to appreciate that this is into two different faces and facets and perspectives. One is the compliance. That means you don't want to be in conflict with the law. And the other is for the wise people who want to make use of the facilities or the benefits which have been offered in these new laws. They need to devise their strategy to improve their business and improve their productivity and aim at growth and progress. So, so it is two parts. One is simply bare compliance to avoid conflict with law, and the other is strategy and growth of business. So I'll always be addressing the whole thing into two parts. Implementation of industry preparedness. Okay, consolidation and consonance. These laws have been brought in consolidation and consonance of various concepts and understanding of what we actually mean. Like Mr. Bhavan said, wage had different definition and different laws. But now we need to understand very simple thing is that the simplest definition of employer and employee definition of employer and employee is job done, wages paid. But if the job is done and wage is not protected, then where is the law? Now what is the wages? So then each time if the definition is different, there is going to be conflict. And will be cause of confusion and litigation which has been for so many years. But now we are looking at a uniform definition across the law, all the laws and for all purposes. Convergence and direction. Convergence means the unified thought and a certain direction. What are these laws made for? They must first of all serve the conform to the provisions of Constitution of India that protects the rights of the citizens. And then to be very specific, the right of the business to conduct business as in Article 19 of the Constitution of India and various working conditions as assured in the Constitution of India for working people. Like for example, earlier the health, safety and working conditions were only governed by under the Factories Act and service sector was not covered at all. But now that is a universal right. So things are very simplified now. That there is a direction that on the workplace everybody needs to be protected. Then is conjunction of operation and operational aspects. How do you administer the law? From the enforcing agencies is one thing, but for the business, the compliance is something very prestigious and important. And for the working class, it is a matter of right. So it has to be simplified in a way that everybody gets their due as provided in the law. And then the one pain in the neck was Inspector Raj. Everybody used to make so much of noise. Inspector Raj, Inspector Raj. Corruption has been a part of our life for so many years. Now at least there is one area where the Inspector Raj is going to be out. The very law part. The inspector is not called an inspector anymore. He is also supposed to guide the industry to implement. Here I would like to point out that earlier the prosecution was for the purpose for violation. If an inspector comes and he sees a violation, he could simply go ahead with the prosecution. Not now. Now he has to first guide the employer that this is deficiency and you have to improve it. He has to give an opportunity of improving the compliance. And then if he does not do it, then he'll have to give a warning and then that warning, if he doesn't do it, then there is a prosecution, means the offense is commutable, the fine is commutable, and then comes the full fine without commutation. And the last stage is very tough, that if somebody is a very hardened offender, then the prosecution is going to be very tough. The heavy fines and even imprisonment has been provided for in the new law. That means people have to be very careful that the earlier habitual offenders and those hardened offenders will not be spared anymore. They'll have to face very tough legal situations if they do not comply with the law. Next. Now, on the challenges and opportunities, as I said, I will be talking on two fronts. One is opportunities for the business to strategize and make use of the opportunities being provided by the new law. And on the other hand, for those who are simply talking about bare compliance, merely compliance, so that they are not in conflict with the law. So challenges and opportunities for business: induction of new technologies. Now here is the law which promotes that you bring in changes, and the law will support you. Earlier, if you wanted to make changes and introduce new technology and restructure the workforce, it was very difficult. You have to seek the permission of the government to lay off, retrench, or close down a unit. Not now. Now, up to 300, you don't need the permission of the government to lay off, retrench, or close. So that is why restructuring is the name of the game today, and that's where we keep talking about it. I'm normally involved in projects for restructuring. And the other thing is, once you are having new technologies coming in, then the human resource competency also has to be ensured. You can't spend a lot of money on new machinery, new technology, and deploy incompetent workers, because you will damage your machinery and you will damage your business. So here is again a chance where employers cannot be burdened with people who are incompetent. The employer has a chance, an opportunity to get rid of workers who are not competent. When he is introducing new technologies, he will have to take people who are competent enough. And training and retraining has become an integral part of it, which was never talked about earlier in any law. Who nobody was bothered. Training and retraining. So much so that if the workers are retrenched, there is a very interesting feature of the new law, that if you are closing down or retrenching workers, a certain amount has to be deposited in a corpus with the government for retraining of workers. Retraining of compliance management. Again, that is a very smaller part. I do not take it as very important, because these are people who are just at the bottom, who are only looking at compliance as a subject. I feel that only compliance to avoid conflict with the law is just a very minor thing. Every entrepreneur, every business, every manager, every senior person in the business field should aspire and look forward to progress, profits, return on investment. And mere compliance of laws to avoid conflict is a bare basic and a very fundamental thing. That should not be a aim. That should be only a starting point. But it is for business. Business is not not for you see, only for compliance of laws. Business is business, and for progress and financial, economic progress and social progress. And then value addition. That is the name of the game in business, any business. Next. So there was a survey sometime back of about 1500 industries, and sadly enough, it turned out that only 40% of the industries is fully ready with various aspects of implementation and compliance of new labor codes. And partially ready is only 22%. I would put them in a discount, because very small percentage and they have long way to go. And early preparation is again a very small percentage. Not initiated is, they were going to get into they are going to come face a surprise. because they are still sitting in a negative inertia. Here I would like to touch one very specific point, that a good number of industries are used to running their business with exploitation of labor by engaging only contract labor and not deploying using modern methods to engage regular workers and managing them well. So now contract labor is going to be a big blunder block. You can't deploy unless in any core function you cannot use contract labor anymore. I'll come to that very specifically. So this is a very big field where you have to restructure your workforce. Okay, next. Universal applicability, applicable one. Conceptual change under the new codes. The concepts, there is no conflict between various concepts, certain concepts in different labor codes. They all are unified and union directional. Definition of employer again has rather become broader. Earlier, the Bhopal gas tragedy focused on only the occupier. Now, now anybody, because a lot of contract workers died in these accidents, and the principal employer said, not my business, it's the contractors workers. No, no, no. Now employer person includes a contractor. The employer, the principal employer is responsible for the compliance for the employees of the contractor also. All paid employees are counted irrespective of nomenclature hierarchy. No, it says he's a manager. No, no, no. He's a worker. No, 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 no. Those distinguishing things are over. Now imagine a supervisor or a manager. He is also entitled to wages. Suppose an employer does not pay wages to an employer and a manager. He also has the right to go under the wage code and claim his wages. Earlier that there was a problem that under the Payment of Wages Act, unless you have less than 20,000, you couldn't make a claim under the Payment of Wages Act. Now it is not that. That limit has been removed. Anybody may be drawing, say, 1 lakh or whatever, irrespective of the amount. I know a good lot of industries where they have a habit of grabbing and not paying wages to the managers on their departure. And then what is wages after all? What is the definition of wages? That is a very ticklish part where I get a lot of questions from all quarters. You see, let us be very, very frank. Earlier, the employers, people either in the finance or in the HR, they were doing a lot of manipulation. The wages, gross wages, only 10-20% of the gross wages was being labeled as basic wages. And then various allowances to cover up various, the amounts and for a total. As a result, the bonus was only based on basic and HRA, etc., etc. And similarly, leave with wages, gratuity, again, it was all scaled down to a very small amount, 10-20% of the gross wages. How about the rest of this thing? Now the code on wages has made it very, very simple that no wage can be an employed person cannot have a wage scale in which there are less than 50% of basic. So the definition is very, very ticklish. I would request all who are seriously interested in this subject to in a slow motion, read the definition of wages in the wage code. And you will appreciate that it is basic wage is not less than 50% of the gross and plus HRA plus retaining allowance or whatever. Sometimes people are covering up various allowances and incentives in the form of incentives and not paying full wages. And they pay wages in such columns that they cannot be claimed. It is not possible now. Read the definition of wages in the wage code slowly and you will appreciate that now that cover up and manipulation is not possible. Those who are members of the PF and ESI, the deductions will be made as per the definition of wages. Now, earlier there was a problem that definition of wages in ESI was different and PF was different and other laws it was different. ID Act was different, not now. Now it is a universal definition applicable in all the laws, and deductions will have to be made according to that. Online wage and record. Now, those who are talking only of compliance for the sake of it, for them also the good part is that it is made very, very simple. No more registers and pile of registers. Now you just already it has been made mandatory that wages have to be paid online, and the record has to be maintained in soft online records. So manipulation will not be possible. And then people who are manipulating, somebody is giving wages on 7th, somebody is giving on 10th. There was a problem in the earlier law that if 1,000 or more workers are there, you could pay the wages on 10th of every month. But now it is universal, this thing, because the efficiency is brought in because of electronic systems and online record making, so that wages must be paid on 7th of every month in any establishment and online. Next. Shivam, next. Code on wages, unbooked liability. Now, this is a big thing which needs to be understood. Those who are very sensitive to these changes, that once the definition of wages has changed, what is going to be in fact affected, and there is a blind spot in the minds of many. If your basic wage is going to be and the this thing is going to be minimum is going to be 50%, straight jump of provident fund deduction is going to be there. Your bonus amount is going to jump. The gratuity will jump. These are not yet calculated, and people don't think on these lines at all. Leave encashment every year. Now, leave encashment is another catch. Earlier, there were establishments which were having provision to continue, accumulate earned leave for more than 30 days. Not now. It is provided that leave can accumulate only up to 30 days in a year, unless there is very specific provision in the condition of service or there is an agreement with the union. Otherwise, the rest of the amount has no. But somebody has to be very wise to understand that if you are accumulating wages beyond 30 or say more, I even know a MNC which has got provision for accumulating 150 days earned leave, which is ridiculous. That means you are providing for encashment of wages at a much higher rate later on. What is this? You're not money wise. Anyway, leave encashment, terminal dues, retrenchment compensation, etc. Gratuity is also terminal due. It's going to be at a higher rate. With the new definition of wage, the gratuity is going to be at a higher rate. Now people have to think on these lines that your liability for bonus, the quantum of bonus will increase because of change in definition of wages. Your PF liability is going to go up because it's not only 12% of the employee, it is 12.5% to be paid by the employer also. So overtime calculations. Again, overtime used to be paid at basic, which was to be 10 to 10 20% of the gross. Now it is going to be basic, which is going to be 50%. So leave encashment, bonus, these were not counted earlier. But now you will have to account for all these changes, enhancement in the finance people are very thickly involved in this. Those who are from the HR profession, I would suggest that they should not take initiative of their own. Let the higher management, especially the finance people, understand what is going to be the liability, and let them understand the new structure and let them strategize how they have to restructure their manpower, their competence. You should not be engaging fools or incompetent people. You should engage only competent people and pay them well. So let the management, higher management decide what kind of manpower they want and what kind of strategy, long-term strategy they want for better returns on investment. Challenge and opportunity, rationalize pay structure and cost of HR. Okay, these are challenges and opportunity also. Okay, next. So coming to specifics. Now, where you have large employment, large number of workers employed, this is a very sensitive issue. Industrial Relations Code, definition of worker and employee. This has become very, very clear. Earlier, we were guided only by case law, and this was very controversial. But now it has been made very simple. Definition of industries also become very, very simple. Earlier, anybody could put in a case and raise a dispute. And because of court rulings, the charitable institutions were also not exempt. They were also included in the definition of industry. Now, somebody making prasad in a temple kitchen was also a workman, and that prasad making workshop was a industry. Not now. If it is a charitable institution, they are not included in the definition of industry for the purpose of industrial disputes. Earlier, the standing orders was a very, very ticklish issue. Standing orders, most of people are not bothered about it. This is a very, very sensitive issue because standing order is a extract of all the labor laws and is the administrative format for implementation of various labor laws. But people have not been attending to this. Now it has become a universal feature. Earlier, only 20, 25 or 50 were workers, establishment having 25 or 50 workers were required to have their standing orders. But and then get them certified from the certifying officer of the government. But now it is not there. Now it is, if you have 300 up to 300, 299 workers, you don't need to get your standing order certified. You just have to administer the model rules which are provided in the law, in the rules. The other thing is about grievance redressal and industrial disputes. Here I would make a very strong punchline that those in the HR profession remember that you should never let a deficiency become a complaint in the establishment, and never let a deficiency a complaint become a dispute, and never let a dispute become an industrial dispute. What is the difference? There may be a deficiency, statutory or non-statutory, but genuine. So the workers are going to speak out about it, and they will be having a grudge that the management is not providing proper facility. Now, if that matter boils over, and it's a very important definition, discrepancy or deficiency, then it will become a complaint or a demand. And if it is not settled at bipartite level, then it becomes a dispute. And if the matter goes to the labor authorities, that becomes a tripartite matter and an industrial dispute. Why let it boil at all? Why let a deficiency become a grievance, or a grievance become a complaint, or a complaint become a dispute, or a dispute become an industrial dispute? The law has provided for a wonderful thing now, that is the bipartite mechanisms, which was not very suppressed earlier. Bipartite mechanisms are being promoted in the new Industrial Relations Code, that the industry is encouraged to resolve problems inside and not let the matter come out, boil over outside. This is a wonderful thing. And earlier, I had in my 40 years of government service, I have not come across a simple single arbitration of award which would have, was implemented or it was fair enough. I have seen only two awards, but they also failed to be implemented. But now the mechanism for arbitration has become very, very strong. So you have from bipartite, you don't jump to an industrial dispute straight away litigation. No, no, no. There is an intermediate step where you can even opt for arbitration. And it has a wonderful mechanism provided in the law now. And then you have industrial labor courts and tribunals. Again, their working has also been made very structured in the new law. Then earlier there was a very painful thing that some worker would come out from the out of the blue that my services were terminated illegally after 5 years, 10 years of the cause of action. And the problem was that the Supreme Court said the government of India, this appropriate government cannot reject the dispute only because it is belated. It is for the tribunal to decide whether the delay was genuine or not, and whether it could be the dispute is valid or not. But now the law has made it very, very simple that if the dispute is more than 2 years stale, it cannot be raised at all. That means you are curtailing unnecessary litigation. These are wonderful things, the pain points for the industry, real pain points, and now they are gone. So it is for the industry to make use of the situation, improve relations inside, to ensure that there is better productivity, better relations with the workforce, and better return on investment. So, challenge and opportunity: review the policy of handling disputes and improve compliance. So, compliance is become something too basic. So, I'm again repeating that I'm more fond of and more focused on progress. What the aim of the new law is: progress, growth, and return on investment. I am not very happy about compliance or those employers who are only bothered about paper compliance, avoiding the inspector. And now the inspector is not going to help, bother you at all. So why waste time on compliance on paper compliance? Yes, you have to comply, there is no choice. But then to progress is more important than paper compliance. Okay, next. So this was about industrialization code. Next, Shivam. Nitesh, somebody is you managing or the. Another thing was the problem with Indian industry was trade unions, roadside trade unions. I have described this in the earlier webinar that the original Trade Union Act was made not for the benefit of the workers. It was meant for creating problem for the industry, in the Indian industry. Somebody who is interested in academics can go to the Binny Mills case. The Britishers were not able to compete with the Indian industry at all, especially in the textile. Manchester failed to break through in the Indian market. See, in North India, they couldn't do anything. I mean, they were able to sabotage and damage. But South India, they had no control, whereas South India was a very strong market. They tried to instigate people to form unions and create problem in the industry. So there, just imagine in 1926 what trade unions and what worker rights. It was all created and cooked by the British to create problems in the Indian industry. But now that thing had multiplied and grown into a demon of roadside unions and blackmailing in the market. Now you can't have a union. The very specific law has been brought in that a union can be registered only if there are 10% of workers employed in that industry, and then there are seven workers who are amongst them who are applicant. And unless there is from the same industry, you can't have roadside unions. So formation and registration has become very, very. This is again some unions are very critical about it, but they may go to the court. I personally handled that case in which these the law which has been brought in is actually based on Supreme Court rulings. So people going to the court means nothing. I'm very confident about it that the new code is so well framed and so directional and so simple that if somebody wants to play funny with the law, he cannot. Then code of discipline was not there. Anybody could do anything anytime. Earlier, only for specific industry, public sector, or there was provision for giving notice of 14 days. But now it has been made mandatory that if some union wants to proceed on a strike, it has to give a notice. And that notice is not always valid. That notice is valid for 60 days only. That means after 14 days and before 60 days, that union can go on strike, not otherwise. And code of discipline means a union will have to remain in the system and work as per the management rules and not create unnecessary obstruction in the working of the industry. Another thing is that in the service sector there was a very typical problem that the workers used to go on leave, mass leave, and say no, we are on mass casual leave, whereas it was actually a strike. This is a case of State Bank of India about 35 years ago. So there were other examples also, and it was necessary to address the that blackmailing, that workers should not be able to go on mass leave and say no, we are not on strike, and then claim wages. So now the law says that if 50% of the employees go on concerted leave, that will be deemed to be a strike, and they will be deemed to be liable for disciplinary action. And earlier, these unions were misusing the workers' fund for political purposes. Yes, political participation is a right, but you cannot play around with the workers' funds. But then, how to curtail it? The law has now provided that the union can have a separate political fund, and they cannot misuse the funds of the workers for political purposes. They can take contribution to political for the union for political fund, but they cannot manipulate and use general funds for political purposes. Another thing, beautiful thing which has been brought in is negotiating council. Now anybody union would blackmail. No, you have to negotiate with me. No, 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 no. There is a negotiating union and a negotiating council. The management has to understand whom to. Now, if the management is ignorant or not participating, taking care of their workers, they will not know what it means. They have to be involved with the workforce and understand that there has to be negotiating union or negotiating group of people, and they have to be given recognition. So now the law provides. Earlier there was no such provision in the law. Now the law provides for recognition of a negotiating union and a formation of a proper council by the employer in the establishment. And then even recognition, official recognition is also provided for. The recognition is many steps ahead of what earlier it was nothing. The the appropriate government can also give recognition, and the central government can also give federation of trade unions. Earlier there was no such formal recognition of trade unions. Now it is provided in the law, and the government will have to do it. So it is better for the unions to work in a system that earlier so roadside blackmailing type thing is not going to be possible anymore. It is necessary for the unions and organization of employees to work in a framework and in a proper manner so that they can't blackmail the industry. Review industrial relations strategies. So as I said earlier, it is for the wise employer, it is a golden opportunity to review their industrial relations strategies and how to deal with the workers and how to maintain relations and ensure productivity and better return on investment. Okay, next. Nitesh, just go to the next. As I said earlier, the promotion of bipartisan is a very big step. We are trying to promote bipartite relationship and resolution of disputes at the very initial stage. And do not let a grievance become a complaint or a complaint become a dispute or a dispute become a. The law is providing for such facilities. Now, if the employer does not understand this golden opportunity even now, then God help him. You see, the country is moving at a very fast pace towards progress. So it is high time that all entrepreneurs understand what is good for them and how they have to progress. As Mr. Pawan said at the very initial stage, it is the workers who are going to run the units business. Time limit for industrial dispute has already been said. Negotiating unit council, 14 days notice for a strike. As strike has, I think I have discussed this already. Proactive conciliation. Earlier, the conciliation officer or the government authority would adjourn the case. Adjourn the case. No, no, no more adjournment. Tariq pe tariq. That filmy dialogue. Tariq pe tariq. No, 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 no. Now the authorities, the tribunals, the labor courts, and the conciliation officer will have to attend to the dispute and take serious interest in the resolution of the dispute and prevent industrial unrest. So this has become very structured and very important part of the law. Okay, next. Contract labor and core functions. As I said at the very beginning, that people who have been misusing workforce are going to be in for a surprise, because core functions, the contract labor is not allowed at all. Earlier, I have seen very prestigious units being run by entirely by contract labor, and those contract labor are not being paid properly. Their rights, statutory rights, being flouted. Now it is not possible. Those who are actually seriously into the subject, they should read section 2p of the Occupational Safety, Health and Welfare Code, in which the definition of core function and non-core function is given very clearly. And in the Industrial Code, the workers for core function are not allowed to be on contract. But then the law has also provided for something very important, that many an industry are on a today business is very fluid. Somebody may have a business for say just only for 6 months or 8 months or say 2 years on contract. Now you want to engage very skilled worker, but you don't want to keep him for a long term, say 5 years, 10 years. Don't want long term relationship. So then the law provides for fixed term employment. Please understand the difference between temporary employment and fixed term employment. Temporary is for temporary work, but fixed term employment is for certain projects which are very typical and described in the appointment letter. And the important part is the fixed term employment, the condition of service and wage scales are same as regular workers. Another big difference is that regular employees get their gratuity after 5 years. But fixed term employment, the gratuity is payable after every year. Now somebody wants to misuse fixed term employment, engaging in fixed term employment again, fixed term employment again and again. Then they must remember, such people who are unscrupulous will have to understand that the unfair labor practice chapter in the Industrial Dispute Act in Schedule 5 definitions are still there in Schedule 2, and point 10 says to engage workers as temporary casuals and casual temporaries and badlis for the purpose of depriving them of benefits of long years of service. So if there is some kind of employment which is temporary or casual, or only for the purpose of depriving the worker of their dues of long term benefits of long term service, then the unfair labor practice chapter is still there and they will be in trouble. The beautiful part is that the threshold of 300 workers is very important, which I have said earlier. That industry is allowed. Now just imagine that the law is providing for skilled employment for very progressive industry, and even if you have project work, you can have fixed term employment, but in a particular manner, without depriving the workers of their statutory rights. But then again, sometimes you cannot run an industry for a long. Suppose you have to wind up the industry and you are going to change the business altogether. bringing in new machinery. So up to less than 300 workers, you don't need to, or the industry is not running well. You want to lay off, you want to retrench workers, you want to reduce workforce, or you want to close down. Then up to earlier the problem was that for 100 workers or more, if you want to do lay off, retrench or close a unit, you have to seek the permission of the government. Of course, it was very widely flouted provision, but then that was a problem. But now up to 300 workers, I mean 299, if you want to lay off for restructuring, retrench or close down for setting up a new business or bringing in new technology, then you don't need the permission of the government for layoff, retrenchment or closure. Now, this is a wonderful progressive step in the law which is encouraging the industry. Now, it is for the industry to understand the benefits and how the law is promoting their progress, helping the supporting their progress. So, strategic review and restructuring of HR and its costing is the most important thing. Okay, next. Occupational Safety Code 2020. Now, as I said earlier at the very beginning, that earlier occupational safety was limited to Factories Act, units covered under the Factories Act, and those under the, here I quote an example of Microsoft when they had devised a mouse. You people will appreciate that we had a device called a mouse, and this was not very well ergonomically well designed, and was squarish earlier in the early years. And a lady in USA, after working along for a long time, she damaged her wrist. So the lady went in a damages claim against the Microsoft company that because of using this mouse, I have incurred an injury and which is permanent damage to my hands. And it was a very big claim. Microsoft had to settle that claim outside the court. Whereas in India, nobody is bothered. If somebody is asking you to work while standing only, you have no right to talk about it. But now in the service sector, also, if the working condition is not ergonomic, then they are liable under the Occupational Safety, Health and Welfare Code. So definition of factory has been a mandate from 10 to 20 workers in a manufacturing process. Another thing was women employees were not allowed to work in the night shift. Then there came a ruling from the Chennai High Court, which said no, this is interfering with the right to livelihood of a lady employee, ladies workforce, and they said they struck down those provisions, and that is how we did it. Now, if somebody wants to contest the law, they are very well welcome, because these changes in the new law are not our imagination of me or my other colleagues in the core group. These are all based on proper case law from the higher courts. So women employees are now allowed to work in the 7 p.m. before 6 a.m. But then again, prior consent and working conditions have to be monitored, because the post law is very much there. Prevention of sexual harassment, etc., is already there. So you have to give certain benefits, certain conditions of working for employees to work, women employees to work at night. Another thing which has been uh, wrong information being spread in the media is daily working hours to be 12 hours. All wrong. Read the law carefully. The total number of hours per week remains 48 hours. But working hours per day remain 8 hours. Those who are spreading this wrong information of 12 hours are mistaken. They have not read it carefully, or their thinking or their intellect is very limited. Yes, that 12 hours limit does allow you to have a 12-hour shift. That means 4 days a week. 12 4 48. So 48 hours in a week means 12 hours a day. But it is wrong to say that there will be exploitation and 12 hours a day for the whole week. Wrong. It is going to be 4 days only, because the total number of hours of work cannot exceed 48 hours in a week. So the working hours remains 8 hours per day. And the law is protecting the right. Mind you, the first convention of the International Labour Organization, the May Day uprising, was because of working hours only. And the first convention of the International Labour Organization remains there, and we are complying with it. And the working hours will not exceed 8 hours per day. Then there is something about Interstate Migrant Workmen Act, which was a defunct law. Now it has been brought into mainstream and it is going to be enforced in a different way. It is actually more for seasonal activities, seasonal workers who are recruited in their home state to work in some other state. So they have to be provided facilities in their home state for transportation, etc., and in the destination state for working conditions. Just because they are interstate migrants, they are from some other state, they cannot be exploited. As I have said earlier, contract labor and contractor and contract labor. Very specific license, experience certificate has to be provided. Appointment letter has to be provided by the contractor. That free for all is no more. A contractor cannot exploit workers just because they are contractors and they are temporary workers. No, no, no. So these are very important things which are protected in the new code. Safety committee. Earlier, safety committee was only restricted to where you had a 500 workers, then you had to have a safety officer. And then higher, you have to have a safety committee. But now every safety committee consider equal representation of employers and employees will have to be there everywhere, especially where there is hazardous work. So these are very important things. The earlier, as you can see, the broad coverage of working conditions very directly indicates that workplace safety, occupational health and safety is a universal right under the Constitution of India, and it is going to be implemented and enforced through this new code in a very rational and a very systematic manner. It is not only restricted to the safety committee, is not restricted to a individual unit. This is even at a state level and a national level. Also, you have a national advisory board. We in Haryana had a advisory committee, state safety advisory committee of consisting of employers and labor leaders, trade unions. Now this is going to be a national concept, and occupational safety, working safety, workplace safety is becoming a very major subject. You know those days of accidents by negligence and blatant violations is no more. The prosecutions are going to be very, very serious for violations. So we are going very close to implementation of the rights of the working class under the Constitution of India. So renew special focus on occupational safety for better employee trust and discipline and to prevent losses. I have data to prove that in the earlier days when there was poor safety provisions in a factory, the workers were apprehensive and there was too much of unrest. And as the safety subject of safety, industrial safety became prominent, the industrial unrest went down. I can prove it with data. Not only Haryana but countrywide. So discipline is necessary and prevent losses. Now, people who are the employers who are not bothered about safety, they don't understand that if there is an accident, that looming negative feeling in that workplace is going to remain for a long time and their productivity will not be there. So it is very necessary for profitability and productivity that and prevent losses that safety must be a very important subject. Workers should know that they are being taken care of, and it should be part of the management working. Okay, next. So those who don't want to comply with the law, they are going to be in serious trouble. Single registration. Now this is a wonderful thing. Earlier, you had factory registration, you had a workshop registration, you had a shop act registration. No, no, no. So many registrations. 13 laws you had registrations. Hi. Not now. Now every state will have workplace registration only one. Whether it is under the Shop and Commercial Establishment Act or it is a Factory Act, manufacturing unit or service unit. No multiple registrations. Then earlier you had motor transport workers registration, where you had five or more workers in transporting of workers and goods. There used to be a registration again. You had registration for contract labor, you had registration for interstate migrant workmen act. So many 13 registrations, separate registration. Now it is going to be under one single registration, and under that only from that reference you get registration of other purposes. So that becomes very simple. Now, those who are only bothered about monochromatic compliance, 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 this is easy for them, that they will not have to have registers and registers and registers all the way. No pile of registers and no pile of running after labor department to registration दे दो साहब वो and greasing the babus there to provide registration compliance करनी है साहब compliance करनी है साहब ये पकड़ो लिफाफा और हमारे को registration दो no more. Now it is going to be under one umbrella. One registration of an establishment. Under that, you will get various, for various purposes, you will have permissions. No registrations. Now 13 registrations in one shot have gone. Just imagine how compliance has become so simple. Code is applicable to all establishments employing 10 or more workers. Challenge reduce paperwork and improve compliance. Make everything online. So imagine those babus who are there in the HR department on compliance, they are going to be out and AI is going to come in. Somebody who is marking his presence by electronically, you don't need a babu to mark his attendance, so you don't need a register. It is going to be all electronic. Why not do it? Improve your efficiency and don't, unless you are very fond of inspectors visiting you again and again and hanging you for nothing. Okay, next. No, I don't need to explain that everybody is now understood that during the corona lockdown, what is the difference between social security and insurance? Insurance is going to be giving me money after I die. But day to day working, I need backup. Say, for example, paying the fees of my children's education or some improvement in my house, domestic repairs, or some emergency expenditure. That is only social security is going to provide. But whereas insurance doesn't give you anything. The other thing is that home workers, domestic servants, or others who are doing small odd jobs, three-wheeler auto rickshaws, or these platform workers like these Uber, Ola transporters, they have no right. A freelancer who's doing his work on electrical maintenance or who's doing woodcraft, he has no backup. He is also a citizen of the country, so he should be having some social. Gig workers. Now imagine a courier worker who is associated with an organized industry but has no rights of or facilities of an organized industry. He has no provident fund account or membership, or he has no health backup, health service. A poor man who is going to fall ill is going to either die of a disease or he's going to die of taking money from the market for his treatment. Now we will have provision for these workers in the unorganized sector to become members of the ESI, and the government will provide health benefits to them. And they can also be members of the Provident Fund. Very strongly coming up. Now just imagine anybody who's member of the Provident Fund can appreciate that the Provident Fund is giving you interest at the rate of 8.25%. Whereas even at a bank, they don't give you more than 7% or 7.5%. Why not save money in the provident fund? Till now, these facilities were not available. A rickshaw puller on the road, a load carrying worker in the market, or a auto driver or a taxi driver had no right and no support from the government, whereas he is also part of the economic system of the country and a citizen. Now, all these people are going to have a right secured under the constitution, and they will be allowed to become members of the provident fund, and they can deposit money, and government will support them. They will also be allowed to become members of the ESI for health benefits. Okay. So this is where we reach a level that social security is not only for the organized sector, it is for the unorganized sector also. Next. Interestingly, as at the very beginning, Mr. Pawan had indicated that the new codes, what is common across all codes, important things, broader coverage of include all unorganized sectors, gender neutrality. Earlier, the Equal Remuneration Act spoke only of equal remuneration for ladies. But now, even if a male is being discriminated because some ladies are going to be favored, he can also make a claim. Common definition of wages. This was the biggest problem, as Mr. Pawan has said that when he was a student, this was the biggest puzzle for them. Universal safety and health, ease of compliance, because everything is going to be soft online. Inspector as a facilitator, nobody is going to harass you. So what is common across all codes? Just imagine the facility which the new law is giving. Now, if the entrepreneur, the businessman, the managers don't wake up, make use of this golden opportunity, that's their bad luck. I would say this is a wonderful opportunity to improve. And if they don't improve, of course, stringent penalties. The inspector or come facilitator, he's not called an inspector anymore. He is facilitator because he has to guide the employer to comply. And if their compliance is not there, because now the prosecution is not for violation, it is going to be for compliance, non-compliance. That even after guiding and even giving a warning, even employer is not complying with the law, then the prosecution process of legal action will come in, and that is going to be very, very tough. Penalties are very heavy, even for commutation and for full penalties are going to be very heavy. And if they don't, if they are not deterred by penalties also, then the prosecution in the court, the penalties the in the law, criminal prosecutions is going to be very tough. Okay, next. Strategic restructuring and HR costing. Contract labor and core competencies. People have to restructure their workforce. Look, be very focused on what they need to have more technology oriented business and having and must have workers who are qualified and competent and stop relying on all that kachra, contract labor, contract labor, contract labor. That old theory is over. Not allowed. It is a golden opportunity for people to develop and progress with technology and competent people. And even if there is a problem with structuring, restructuring, or you want flexible working in the new modern times, yes, flexible working is possible with fixed term employment, and then for whenever you want to lay off, retrench, or close, you can do the restructuring wherever you want. We are specializing in restructuring. Here I would say that there have been very, very intelligent people in the industry, and they have been talking of VRS. Now just imagine the General Motors unit manufacturing Ford vehicles. They had paid big amount to their workers as VRS, 50 lakhs, 60 lakhs, 70 lakhs, but the worker was still on the road. Murdabad, Murdabad. What does it mean? Those highly qualified managers did not know how to calculate what is a VRS. What are the criteria for making, evaluating a VRS? Or what is the system and what is the process? People need to apply their mind. Now, if they don't apply their mind, here is the law, which is giving them a beautiful incentive and a motivation and a gateway to better working. Cost of and administrative impact. Now, if people, the wage structures are going to change, it is very important to assess, especially the cost of HR and unbooked liability is going to be very, very important. So, I call upon all viewers and everybody in the industry to look at this very carefully because these are things which are going to change. If the definition of wage is going to change, your unbooked liabilities are going to be very, very different. And if you are not aware of it, you are going to be in trouble at some point of time. Okay, next. Business establishment to employ 20 to 70% manpower through outsourcing. Whereas in the practice, severely restricted in the new labor codes, section 2P OSH code. Please note this. Those who want to read this, you can read section 2P of the OS and Occupant Safety Health Code. And you will come to know what is core function and what is non-core functions. So the challenge is what would be the new organizational structure to meet the challenges of the future business heavily dependent on technology and skills. What are your plans? Are you prepared for the opportunity? Okay, next. Challenge and business opportunities for business. As per the definition of basic new wage code, the component of basic wage has been fixed at not less than 50%. Similarly, the structure of wage was ruled upon by the Supreme Court in the Provident Fund deduction. What would be the resultant change in the costing of manpower in general and in the high pay bracket among supervisors and managers? Now that is very interesting. That employees in the higher pay bracket, supervisors and managers, they were not getting that kind of money. Now, even they will have to be paid at that level. You can't have a manager with less than 50% of basic. So, this is going to bring a lot of liability on the finances of the company. What are your financial restructuring plans for costing of HR? Are you prepared for the compliance of the new law? Again, I focus on people who are only focused on bare compliance, mechanical compliance. They also have to be careful. Okay, next. The new business working requires ever-changing technology and specialized skills, but the manpower needs are extremely variable as per availability of business. What are your plans for flexible working, manpower structuring without conflict with the law? This is a wonderful thing and very an intellectual approach is required for this. The management needs to brace up. Every management, whether in the service sector or in the manufacturing sector, has to brace up. Now, in the software area, say service sector, the AI is playing havoc. Now, people who are not trying to understand the technology changes, they are going to be in for big trouble, a big shock in the coming times. So, plans for flexible manpower structuring without the conflict with the law. Okay, next. So, God bless you all and God bless India. I think I have tried to distinguish very clearly those employers who are interested in progress, development, strategic functioning, and those who are interested on paper compliance. I am with those who are into development, progress, strategic working, and restructuring of flexible working and for better profits and progress.
Thank you, Anupam Malik sir. We are running out of time, so
Yes. I think a lot
again
of.
request to Nitesh Latwal sir to give
Uh-huh.
his presentation.
Haan ji.
Thank you, sir. Thank you. Dear friends, we will now touch upon the wage restructuring part. Anupam sir has given some views on it. That because we are at the closure of the financial year and many companies are at the stage of finalizing their accounts, so they must be computing some that's Anupam sir has already highlighted the unhidden liabilities. Unhidden liabilities may be in the form of your statutory liabilities towards gratuity, your liability towards leave encashment, your liability towards bonus, your liability towards PF and all. So all has to be restructured according to the wages which we need to recalculate as per the code. So as Anupam sir highlighted that the definition of the wages has been kind of universalized in all the courts, because in under existing labor laws there are a different definition under each law, because the that laws were implemented in various point of time. So given their the objective of each law, they have come out with their own definition. Now that has been streamlined. So today we have a universal definition of wages. Um, so we will jump on very fast because the time is very short with me. Next, Shivam. So these are the wages code. These are the codes where a uniform definition of the wages has been introduced. If we look at the definition of wages, it says that wage includes a basic pay, DNS allowance, and retaining allowance. All these three are the parameters which are included in the wages. So if anything comes out there, so from there we need to calculate the statutory liabilities of the employer, whether it be a PF contribution, whether it be a ESI contribution, whether it be a gratuity, or whether it be a bonus. So we have to calculate uh, all these things from the definition of wages, that is including three parameters, that is basic pay, DA, and retaining allowances. So what is not included? The bonus, obviously, the bonus as per the statutory law, under which every employee is getting the a kind of minimum bonus. Then your commission, then your HRA, then your conveyance and travel allowance, then the employer contribution. Employer contribution, why it is excluded under this? Because there are many companies who have a very good basic, which is beyond the statutory limit. They are paying a contribution on the basic beyond a minimum limit, that is 1800. If they calculate at a required level, that is 15,000, because there are many employers who are giving beyond these limit. So they want to restrict it. If they are giving beyond the statutory limit, obviously they will form part of your basic pay. If we comply with the 50/50 rule, if we apply the 50/50 rule, now there is a overtime wage allowances. If anybody is giving, that is also excluded. And there is the under the exclusion part, there is also two things, that is a gratuity liability. If there's a gratuity liability, and there's a retirement benefits if the employer is paying. Next. So 50/50 rules are applied. 50/50 rule is nothing but a part of a definition which says that under the clause of the definition clause of the wages, if 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 clause A to I, if it exceeds your basic D and retaining allowance, if it is goes beyond 50%, then it automatically becomes part of your basic pay. That means if there is a disbalance between basic pay and other allowances, or if allowances is greater than your basic pay, then the excess part will shift to the basic pay, and there is a kind of higher liability to be paid or to be contributed by the employer. Next. So there are various FAQs which has been introduced or released by the Ministry of Labor and Employment. So if you see one of the kind of example which they provided in one of the latest FAQ regarding the how you calculate the kind of basic pay or restructuring of wages as per the code. If you see this example, so they have kind of considered CPC 76,000, wherein basic and DA is 20,000, relevant allowance 40,000. Relevant means the clause A to I, and the excluded allowances, that is 16,000. Let's say example, it is a gratuity. So if they are applying here the 50% test on the CPC, I think this FAQ is not very, I would say, in my opinion, is not as per the requirement of the code, because they apply the 50% test on the CPC. Whereas under the definition clause, it is not like, or it is not required that you apply the 50% criteria on the CTC. I think we should apply the 50% criteria on the gross payable, excluding the gratuity part and the retiral benefits, because that is the sum you are getting, not monthly. That is the sum you are getting when you exit from the company. So I think this one of the FAQ where they kind of highlight the what is the restructuring formula of CT's salary or the wages is not as per the requirement of the code. And in all the FAQ which is recently released by the ministry, they have a disclaimer that these FAQ are the guidance. It is not like this is a law. If there is a law which is saying otherwise, the law will prevail, not the FAQ. Yeah, next. Shivam, next. So, what is the impact? As we discussed that once we apply the 50/50 criteria, we definitely have an impact. There may be a chances that salary would get increased, as we discussed in the earlier slides. Long-term impact would be
webinar.
more amount of gratuity payable, a more amount of leave encashment, and there's a direct cost involved over the employer. That is a 20. The percentage remains the same, but if due to restructuring my basic pay gets increased after applying 50/50 rule, then there is a higher contribution of PF by the employer. Obviously, gratuity and other benefits like leave encashment and bonus. Next. So before that, I would like to kind of share one of the view with all you, that while uh, there is no kind of while you restructure your wages, there is no always kind of consequence that you will able to, there is a consequence of getting the higher wages while applying 50/50 rule. If because the if you read the definition clause of the wages, then you will find out that there are uh, kind of uh, ways that you can restructure the wages while there is no while without any increasing in the gross pay, without any increasing any liability, because there are few allowances, there are few payments which do not form part of the wages either in first part or second part. The wages in the form of performance bonus, not the statutory bonus. Performance bonus means uh, uh, a bonus in the form of incentive basis upon your performance. There are many employees which are getting ESOPs. There are some allowances which is kind of required as per the role of a particular employee or wages or employee or worker. So those things neither included in form part of basic nor form part of the excluded allowances. And ministry has also clarified in their FAQ that these kind of allowances or incentives which are contingent or which are connected to any a role of any worker that does not form part of your wages. So if we kind of restructure the wages while complying with the 50-50 rule, so there are chances that we do not kind of result in payment of higher wages. So if you do not, if that is the case, then we can kind of content the liability of the employer. So there is no kind of a kind of bigger liability which will come in my balance sheet if we restructure in a way that I can I can comply with the 50-50 rule, and at the same time I will not increase to a certain level of the wages of the particular employees or a worker. Sir has also discussed about the overtime. So there is obviously a doubt whether if a worker work beyond 8 hours or 9 hours in a day, but it kind of work within 48 hours in a week. So whether we should give a overtime or not. I think in one of the FAQs of ministry, they said either you work beyond 8 hours in a day or you work beyond 48 hours in a week, then you have to give uh, a overtime wage to your worker. So the overtime wage rate is 2x of your normal wages. Next. So there is also a very kind of confusion regarding leave encashment. So leave encashment kind of a very high liability which you see, because earlier there is a very kind of restricted list which is covered under the Factories Act, which covers very few categories of workers. But under the new code, now everyone is covered except administrative staff, a managerial staff, or supervisory staff who is withdrawing a salary more than 18,000. So, now since, and this liability has to be complied with after the closure of a calendar year, because the 31st December of making the pay, the 31st December is the trigger date when you calculate your leave encashment, and by that time the new code came into picture. So now the 31st of March is there, so we need to kind of calculate the leave encashment liability as per the new code. There's one clarification given by the ministry in FAQ that how we calculate the leave encashment. So they said that leave encashment has to be calculated as per the new code. So it means if we say as per the new code, then we have to calculate the wages as per the new code, and the liability has to be recalculated accordingly. And there's also a kind of limitation, there's also kind of one condition that uh, that leave encashment, if there is accumulation of leave encashment, so beyond 30 days it cannot be accumulated and carry forward to the next year. So we have to encash it before this 31st of March, just to comply with the requirement of the code. So we cannot go beyond 30 days. We have to encash to the respective employees and the workers. And as far as the exclusion part of the employees are covered, that is administrative staff or management staff or the supervisory who is drawing 18,000, they are continue to be governed by the respective states laws, that is Stop and Establishment Act. So they will have the same kind of understanding here under the various Shops Establishment Act. The leave encashment is generally guided by the contract of services or a contract of employment. So they will continue to be governed by the respective state laws. Next. So that I have already discussed that gratuity, while the gratuity restructuring will also be a part of once you're done with your wage restructuring, because in 31st of March you have to recalculate your gratuity and fix that liability in your balance sheet. Under the regular employee, the kind of condition of 5 years was there in the earlier act, and it is remained the same under the labor code. Under the fixed term employees, there is a kind of condition that if they complete a 1 year of contract, they will get the gratuity once they complete the 1 year and they exit from the company or the contract has come to an end. So there is one question so there is one FAQ which is there in the one of the uh, one question with respect to the FT. Since the FT, the fixed term employees is first time in India recognized under the code. Earlier, the company has a practice of entering into a one-to-one contract with the employees, and they continue to remain as a contractual employee for years, 2 years, 2 years. Now there is a question that this code generally the social security code wherein the gratuity part is there for the FTE. So there is a question that if there is an employee which is there for the last 6 months, and on 31st of December his contract expires, whether he is liable for the gratuity or not. So in one of the ministry has answered is in affirmative way. So they have kind of clarified that we have to calculate the 1 year from the date of the contract. Even if when the contract has entered into, there was no requirement, but now the new code has come into effect from 21st of November. After 21st of this November, if somebody falls under the definition of fixed term employee and their contract has come to an end, so we have to calculate the 1 year from the date of the contract, not from the date of when the law came into effect. Next. So this is the thing I explained. Next. So there are many questions which we used to receive, that what is the liability of the contract labor. So even under the previous law or under the new law, the kind of parameter is same, the kind of premise is same, the rule is same, that the primary liability towards contractual employees will remain with the contractor. And if he fails to carry out his minimum requirement like wages, bonus, gratuity, if they fail, yes, the secondary liability or pecuniary liability falls on the principal employer. And the principal employer has the kind of right to recover from the contractor. So this is the same even under the old law and under the new code as well. Next. So if I kind of sum all the things which we discussed in the earlier presentations, that what kind of steps we need to take care while while finalizing our balance sheet. So we need to first restructure our wages. We need to recalculate the statutory liability which is there to be disclosed in my balance sheet. That is gratuity, the leave encashment. So all these things we need to take care of. But you first need to start with the restructuring of wages. That is very important. That is how you will kind of disclose the fair and true you can say a true and fair view of the affairs of the company, or true and fair view of your finance of the company. Next. So yes, as I discussed, as I already highlighted, that you need to first kind of do the maths with respect to restructuring of wages, with respect to the CTC, with respect to the social security contribution, either in the form of PF, gratuity, or bonus. Then we need to kind of, at the same time, we need to revise our policies with respect to fixed term employees, with respect to our leave encashments, with respect to our kind of hiring the contractual employees. Next. Okay. Oh, so this is from my side. I think we have received sir, few questions.
Yes, sir. Sir, we have received around 15 questions. So now we have to address them. So first question, what I have received on email. Section 60, subsection 4 of the Social Security Code 2020 provides that a woman who legally adopts a child below the age of 3 months is entitled to maternity benefits for a period of 12 weeks from the date of child is handed over to the adopting mother. Recently, the Supreme Court, comprising Justice J.B. Pardiwala and Justice R. Madhavan, held that adopted mothers are entitled to maternity leave irrespective of the age of the child and struck down the restrictive provision under Section 60, subsection 4 of the Social Security Code. So now what is your view on this and what is the status of Section 64, 60, subsection 4 after this judgment? Anyone can answer on this.
Anupam sir, can you give some right?
I think Supreme Court is supreme.
Okay. So there is one more
If they said
question
so,
with,
it is right.
okay.
I
So there is one question with respect to, I think
tell
I
you
have
the
covered
letter block.
this, but I
Why the
want.
question is? I'll tell you the cause of the question. Tell you the cause of the question. The cause of the question is that a good lot of ladies are misusing the provisions. What they are doing is that when they come back after the maternity leave, they simply put in their resignation. I mean, they have taken the money for the maternity leave and came back and left the job. That means they are not interested in no loyalties with the employment. Similarly, this is another situation for maternity leave. I think I agree with it
Sir,
because
we have
So
received.
we are focusing on the child actually. Let us be very straight.
Okay. Sir, we have
Shivam,
received a lot
we,
of question on the applicability of the labor code. So one asked that new labor code have been notified, but rules have not notified. Then what is the enforceability status of the four new codes as of date?
Let us be very simple and straight. The provisions of the law will supersede any rules. So the principle of the law which has been notified will apply. The rules are only procedural aspects of the law. And most of the states have already come out with their rules. And shortly they are going to be notified. I think many of them have notified and declared. But some of them have called for objections. So this is just a matter of, I can't say weeks or a month maximum.
I
So, but
think,
the law is
yeah,
very much applicable. Let us be
yes,
frank.
yes, yes, yes. I think in one of the FAQs released by the ministry, they have clarified the position that law has already come into picture. Rule which is there in the which is there under the state laws will apply, but if they differ or if they in contradiction with the labor codes, the labor code will apply.
Okay,
So
man, let
there
me
is
make
what,
it. I've handled a situation. I've handled this
yeah.
particular situation. I'll give you a very specific answer.
Mm.
You see, that conflict with the law, new codes should not be there. But otherwise, the continuity with the past law and the new law is there. If there is some formality which is provided in the rules of the previous law, say industrialist Britain,
Mm.
that formality can be used from the previous rules to apply for the new this thing. But
Yeah.
the new code will definitely apply. For example, 300 workers, the retrenchment or closure is permitted. Of course, the notices which they have to go or the intimation to the government, which is provided for in the rules in the Industrial Act, they can use the previous format or simply intimation can be made. But then the new law cannot be bypassed. The new law is giving a facility which will remain very much valid. That is there. So
Sir,
just because the new rules have not been notified, that doesn't really mean anything. The old rules, the old authorities continue to be there.
So one more question is with respect to who are all covered under the definition of workman under the Industrial Relation Code.
You see, this is very simple. A person who is employed, that it definitely remains the same as in the Bangalore water supply case. A person employed for hire and reward for producing of particular results, working under the supervision of a particular person, is an employee, is a workman. And the negative definition is that he should not be having any financial or administrative authority. He is a workman.
Okay. Shivam, any so there's
whether
yeah, yeah.
incentive payments based on performance form part of wages.
No,
No, but then I would suggest those who are interested in real more details
restructuring.
academically, please read the Vivekanand judgment on Provident Fund. In para 14, the Supreme Court said that we are not giving affirmative judgment on this because there is lack of documentation available in the case. But then they said that if there is a variable payment of wages stated to be because of variable performance, then it has to be documented. If there is lack of documentation and proof that the variable performance is the cause of variable payment, then that will be a cover up. That will be treated as a farce. And that amount will be merged into the basic. Now, here a big question which is looming large and unanswered is, can that amount exceed 50%? No, again, that will remain in 50% only. But then this is not included unless it is documented. Variable performance is not documented, then that variable pay is not wages. It is wages. It is
Okay, sir.
wages.
Sir, present wage limit for ESI is 21,000 rupees,
Yes.
which includes all payments, including incentives. Under the new code, that is, the rules have not been notified yet.
No, it
Therefore,
remains the same. Yes.
which payments should be considered for contribution? Only basic plus DA as
There is
per
no
the new code.
no change in the law. In
Okay.
ESI, there is no change in the law.
Sir,
But for
if
the
a person
purpose of calculation, for the purpose of calculation of wages of 21,000, you need to calculate as per the new code.
okay.
Okay.
You see that barrier is broken. Try to appreciate there is the barrier is broken. The manipulation which was
Mm.
being done earlier was that people were deliberately keeping the basic down. Now the
Mm.
basic is already up 50%. So that manipulation is not possible anymore. So then it is included. The new wage code defines wages very well, and that is going to be used for ESI or PF both.
Sir,
I'm
if a
expecting
person
personally, I'm expecting the PF coverage also to go up in the in near future.
Sir, if a person working in a government hospital, whether he will be treated as a worker under industrial code or not?
Yes.
Uh, okay. What is the definition of wage as per gratuity? What is to be included?
You see, now the definition is the same, universal. Wage code definition will be used everywhere. We are not deviating.
Whether new labor code is applicable on contract employees resourced through contractor?
Yes, very much.
Yes.
Very much. On the contrary, something more is imposed here. That the contractor will have to give an appointment letter. He'll have to give a I card, which was earlier in the rules and was being flouted. Now the contractor will have to provide experience certificate. He'll have to give appointment letter, and he has to give. No, contract labor is not going to be that kind of joke which was there earlier. Exploitation is not possible anymore.
Sir, if monthly performance-linked incentive exceeds the 50% rule, will it be considered as a wage?
No, no. Then again, variable, this thing is documented, then no. If it is not documented, then it is part of wages.
If my minimum wage is 11,000 rupees, then can the structure be broken as basic salary 6,000, allowance 5,000, such that the overall minimum wage limit is satisfied?
No, 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 no. They cannot split it like this. Of course, there is a ruling from the Supreme Court in the case of Haryana. We lost that case. The Supreme Court says no, you can split it into HRA and basic. But now in the new code, that is not possible. Minimum wage remains minimum wage and lump sum. It is called basic and DA. Minimum wage is very clearly defined in the new wage code.
Sir, leave encashment is calculated on basic or minimum wage of 50% of CTC.
No, no. First of all, I want to clarify something here that CTC is a wrong usage. CTC is an accounting concept and nothing to do with labor laws or anything. No law. CTC is a wrong usage, wrong concept. CTC is an accounting concept which is for the purpose of calculating the return on investment and the cost of working. Cost to company means cost of working, and it's nothing to do with the law. The wrong usage. If people are you see it, yes, it is part of a appointment letter. They write CTC, but this is wrong actually. Do not try to mix CTC with wage. Definition of wage wrong. That is where they
So,
get into trouble.
what about the labor welfare officer in new codes?
Yes, in the Occupational Safety, Health and Welfare Code, the labor officer is definitely there. Labor welfare officer provision is still there. And more than that, you have a safety officer separate, and then you have other safety counselors. So many, it's expanded further. Safety is a focus now. Occupational safety is a very strong focus.
Sir, ESI will be calculated on basic or gross wages?
No, total.
Okay.
Nitesh
Uh, for,
explained that very well.
for application of standing orders, whether the count of 300 will be workers or workers and employees. For example, in the factory, if the workers' strength is around 200 and the employees in other function exceeds 125, whether standing orders will be mandatory?
What a standing order is there, you are defining the who is a worker, who is a manager, and whether they are included or not. Workers are included in 300, and whatever is defined in the standing order that will prevail. If the manager are not included in standing order, then they are not included. Because there is you see, as I said, standing order is a extract of all the labor laws for a purpose of administration in the factory and easy working, and the types of workers defined in the standing orders. So that will prevail. If it is written that it is covered, then it is manager is covered, then it is covered.
Sir, if the company decide to keep the PF capped at rupees 15,000 for all employees of the company, then even if the other components, that is non-wages, are more than 50%, how do we deal with the PF which is already capped at rupees 15,000 per month?
No, that is still blocked here. That 15,000 is the cap, upper limit. Still not. That's why I said just now that I'm aware that in the very near future, this limit of 15,000 is going to go up.
Sir, there is a question on dispute side, whether existing industrial dispute pending as on 21st November 2025 in Industrial Tribunal will be covered under old Industrial Act or
Yes.
new IR code.
No, old Industrial Disputes Act.
Okay.
But their
Wait,
working of the judges, the presiding officers will obviously be governed by the new ones. You see, as I said, these laws are made on the basis of various judgments of the Supreme Court and the High Court. The working of these presiding officers has to be structured, improved, which the new law says so, and they have to. But then the tribunals will remain the same, and they will continue with the adjudication as per the old
sir,
law.
One question is there that wage ceiling for workmen under IR code is in variance with the wage
It is
ceiling which is
already answered,
written.
Shiva.
Okay.
It
Already
is
answered.
already answered.
So
I
ESI
think,
will be hmm.
yeah. Yes, yes, yes. ESI is
Every
already
question has been
answered.
covered.
Yes, yes,
Yeah.
yes. ESI is already answered. It is, we have to calculate wages. The 21,000 is the limit, the calculation of wages for the code.
So every question in chat box and received
Yes,
through
yes, it
email
is
we have
answered.
covered.
Yeah, yeah.
So now this is 6 p.m. So as a ritual, I request both of the speakers to give a concluding remarks for 30 seconds. First, I request to Nitesh sir.
So, as Anupam sir said, so this is the time that we should kind of, we are at the closure of the financial year. As I already mentioned in my presentation, that while we kind of recalculating or revisiting our financial liabilities in our balance sheet, which must be giving a true and fair view of the affairs of the company, we must comply with the law, not not only in the black but also in terms of spirit as well. So every restructuring does not mean that liability will get increased, but you have to apply your mind, you have to see the definition clauses and the recent FAQs which is released by the ministry, just to come while you may also kind of content your liability while comply with the 50/50 criteria. And once you do this exercise extensively or with the help of any expert, then I think it is good to have a second opinion while kind of uh, calculating your statutory liability, since you have to put all the information on your balance sheet, which is which is a kind of a document which is gone to everywhere to all investor, not in India but outside India. So it must kind of reflect the true and fair view of the affairs of the company. So you have to take a diligent step towards recalculating your unhidden liabilities, and Anupam sir said. So I think this is my and also yes, the policy. I think under the labor code, the one part is the quantity part or a numbers part, but the other part is the governance part or a quality aspect, which you need to also take care. Though it is not there disclosing in the balance sheet, but it reflects on the ground. It reflects on the floor of the kind of your factory and establishment. So I think some governing steps you also need to take care. I think this is, I think, kind of a good beginning of the new financial year. I think everybody should be geared up and try to comply within the parameters of the law. That is from my
Uh,
side. Yeah, Anupam sir,
Now I
your
request to Anupam sir.
Thank you. Thank you. While I know it's very, I think we've done a nice one. I'm happy with Nitesh's presentation, very beautifully made presentation, especially the graphics. While supporting whatever Nitesh said, I would repeat what I said in the very beginning, that compliance and implementation, two things. Now there is a new law. We're looking at a revolution in labor laws. So there's a golden opportunity for the wise to strategize and make use of the opportunity
correct, sir.
or promoting business. And those who are dumb and they are just concerned about compliance, 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 let them talk about compliance and be remain in the books. So even they have to be on online. They can't run that manipulation registers because there are no more registers. Everything has to be online.
Mm,
So those who are talking only of compliance at the just for the heck of it, even they have to follow the toe the line, and they may remain stuck with the compliance only. But those who are wise enough, they will talk of progress, the strategy, and growth and profits. So while supporting Nitesh, I researched what I said at the very beginning. That I address the whole situation in two parts: those who are progressing and those who are not
Uh,
formatted. Good luck to all of them. And that's why I
thank
said, God bless India. because we have a wide differential in thinking between various regions, various industries, and various minds. Each one has to think in his own way how he has to carry himself in his business. You can't dictate terms to people. People have to be wise of their own.
So thank you, sir. Thank you,
Good enough.
Anupam
Good
sir
enough.
and
Thank
Nitesh
you
sir.
very much. Thank you. Thank you for the
Now we
questions.
will have our next webinar on 27th, same time 4
Great.
to 6. Till
Great.
then, good evening.